Podcast Bites, powered by IndiaLaw LLP. I am Pranjal Maheshwari, and today we discuss a major Delhi High Court judgment on one of the most pressing legal questions of the digital age. Can a person ask that old court records, news links, or case materials stop appearing whenever their name is searched online? The case is Laksh Vir Singh Yadav versus Union of India and Connected Matters, decided by Delhi High Court on 29 May 2026. The judgment deals with the right to be forgotten, informational privacy, reputation, search engines, judicial records, and the principle of open justice. This is not a judgment about rewriting history. It is about whether the internet should indefinitely amplify a person's past legal proceedings, even where that proceeding has ended in acquittal, discharge, quashing, settlement, or where the information is otherwise private and no longer proportionate to keep searchable by name. The court was dealing with a large batch of petitions. The petitioners came from different factual backgrounds. Some had been acquitted of criminal charges, some had been discharged, some had FIRs quashed after settlement. Some were parties to matrimonial or family disputes. Others complained that their names appeared incidentally in judicial records or online content, causing continuing reputational and personal harm. The common grievance was that their name, when tied into search engines or legal databases, led directly to orders, judgments, articles, or videos that created a damaging public impression. The petitioners argued that discontinuing digital visibility affected employment, reputation, marriage prospects, personal dignity, social standing, business prospects, and mental well being. The legal question before the court was therefore not simply whether court records were public. Court records are public because the justice system is open. The real question was whether name-based search visibility of such records, especially years later and after the legal outcome had changed, can be moderated in a constitutionally permissible way. Petitioners relied heavily on Article 21 of the Constitution, particularly the right to privacy recognized in K.S. Puttaswamy versus Union of India. They argued that the informational privacy includes ability to control how personal information is circulated and accessed, especially when continued digital circulation becomes disproportionate. The court recognized that the right to privacy, dignity, and reputation are important factors of Article 21. It noted that the privacy is not limited to secrecy. It also includes informational autonomy, the ability of a person not to be permanently defined by a digital search result. At the same time, the respondents raised serious concerns. Search engines, legal databases, media organizations, and public authorities stressed that judicial records form part of the public record. They argued that court judgments must remain accessible because open justice, public accountability, and freedom of information are essential to the legal system. They also cautioned that India does not have a broad statutory right to be forgotten in the same form as European Union's GDPR framework. The court did not reject open justice. In fact, it treated open justice as a core value. Judgments and order must remain accessible to legal search, public accountability, precedent, institutional transparency, and administration of justice. But the court recognized an important distinction. There is a difference between making a judgment available as part of the public record and allowing it to be endlessly pushed to the top of the internet whenever someone searches a person's name. The court observed that search engines change the practical impact of public records. A judgment that once had to be found through court files or legal research can now become the first result attached to a person's identity. The algorithmic ranking of search results is not itself a function of open justice. It can amplify old or contextually incomplete information in a way that causes continuing harm. The distinction became central to the court's approach. Instead of ordering wholesale deletion of court records, the court considered narrower remedies. The first important remedy discussed was in de-indexing. De-indexing does not erase the underlying judgment, article, or order. It simply means that a specific URL should not appear in response to a name-based search. So the public record remains available through case number, court name, date, citation, or legal research. What changes is the material is not automatically surfaced as a result against the individual's name. The court considered this as a limited and proportionate remedy in appropriate cases. It preserves the institutional function of court records while moderating the disproportionate harm caused by name-based digital visibility. The judgment also noted that similar concerns can be raised in relation to video content hosted by platforms such as YouTube, where the content appears in response to a person's name and continues to define that person's despite the legal outcome. The court was careful not to create an automatic rule. It laid down factors to guide the decision. These includes the nature of the information, the time elapsed since publication, the continuing relevance, and the material, the public role of the individual, the accuracy and the completeness of the information, the impact on dignity and reputation, the extent of digital accessibility, and the effect on freedom of expression and public records. The court made it clear that these factors are not mechanical checklists. They must be applied contextually. The decisive inquiry is always the facts of the individual case. For instance, de-indexing may be more justified where a person has been acquitted, discharged, or where criminal proceedings have been quashed and continuing online visibility creates a misleading or disproportionate impression. The same may apply where the dispute is purely private, such a matrimonial or family matter, and the public interest in name based discoverability is limited. The court also recognized that de indexing will not be appropriate in every case. Public interest may require continued accessibility in cases involving serious offenses, positions of public responsibility, public accountability, or matters where society has a legitimate interest in knowing the information. The judgment specifically emphasizes that the right to be forgotten cannot become a right to erase history. It must be balanced against the freedom of expression, open justice, public interest, legal obligations, and the integrity of the judicial records. This makes the judgment important. It neither gives an unrestricted right to remove all inconvenient information nor treats every court or record as immune from privacy concerns. Instead, it develops a middle path based on proportionality. The second major remedy discussed by the court was masking. Masking means replacing names and personal identifiers in the publicly accessible digital version of the judgment or other neutral references, such as initials and anonymous markers. The court clarified that masking does not alter the substance of the judgment. The reasoning, findings, legal conclusions, dates, court details, and case information remain intact. The complete, uneradicated version must remain preserved in the court's internal records. However, the court also held that masking should generally be sought from the court that originally passed the judgment or order. This is important because the originating court is best placed to preserve the official records and determine whether public access should be modified in the particular case. Petitioners who also obtained de-indexing were therefore given liberty to approach the concerned court for masking. Ultimately, the Delhi High Court directed de-indexing in deserving cases across the batch of petitions. The directions required search engines operations and legal databases platform to de-index and disable name-based search functionality and respect of the relevant judgments, orders, articles, or content where relief was granted. The court directed that, unless otherwise specified, the direction be complied within 2 weeks. Google and other search engines operators were directed to de-index relevant content from name-based search results. Indian Kanun was directed to restrict name-based search functionality for identified records while keeping the judgments and orders accessible through case number, citations, code details, and date. The court further directed the Union of India through the Ministry of Electronics and Informational Technology to ensure compliance by respondent intermediaries and file a compliance affidavit within 4 weeks. This ensures that the directions are not merely declaratory but operational. The judgment matters because it recognizes that the digital permanence can create a second layer of punishment or stigma. In the physical world, a court record may be public, but it is not necessarily attached to a person's name forever in every casual search. In the digital world, old proceedings can become the first and the most visible marker of identity. At the same time, the court preserves open justice. It does not order blanket deletion. It does not say that judicial records should disappear. Instead, it draws a distinction between access to law and algorithmic amplification of personal information. The judgment therefore gives courts workable framework. It asks whether continued name-based searchability serves a legitimate public interest or whether it disproportionately harms privacy, dignity, and reputation. That balancing approach is likely to influence future cases involving digital privacy, legal databases, media archives, and search engines. The first takeaway is that the right to be forgotten in India remains a developing doctrine. It is not absolute and cannot be invoked to erase public records mechanically. The second takeaway is that de-indexing is different from deletion. The record remains accessible, the name based discoverability is moderated. The third takeaway is that masking is a separate remedy and should not be sought from the court that passed the original order or judgment. The fourth takeaway is that the cases involving acquittal, discharge, quashing, settlement, private matrimonial disputes, or incidental references may present stronger claims for relief depending on the facts. And the final takeaway is that the public interest remains critical, whether information concerns public accountability, serious offences, public office, fiduciary responsibility, or continuing relevance. The case for de-indexing may be weaker. To conclude, Laksh Vir Singh Yadav versus Union of India and Connected Matters is an important step in Indian digital privacy jurisprudence. It reminds us that law must adapt to technology without abandoning foundational principles. Open justice must remain open, but digital systems should not turn every past proceeding into a permanent identity maker, especially where the law has already vindicated the person or whether continued visibility serves little public purpose. Thank you for listening to Podcast Bites powered by India Law LLP. This was Pranjal Maheshwari. Stay tuned for more concise legal insights on emerging issues in law.